I don't know if everybody saw this, but Maryland Realtors put out this email today that they reviewed the Zillow touring agreement, which kind of right off the bat I thought was unusual that they had to even come into possession of that document, but perhaps it was brought to their legal hotline. But anyway, I thought it was interesting. They put this bulletin out to the entire membership specific to this touring agreement that the agreement does not comply with Maryland law. And I thought that was so interesting. So here you have the situation where you have so many brokerages, teams, and agents whose success, a lot of their success is tied to Zillow. And Zillow, in trying to comply with the NAR settlement, requiring this agreement before touring homes, created this nationwide touring agreement for their buyers agents, I guess, to use. And of course, Zillow, most of their revenue is tied to selling buyer leads, although of course they're trying to pivot on that. And if you go online, if you look at a lot of videos on this topic, you'll see that a lot of the real estate community is unhappy with Zillow. I guess if you're profiting from Zillow, you might like Zillow. But there was a time where listings were not syndicated to these portals. And what happens when your listings are syndicated to portals, of course, is leads on your listings are either bought by you or sold to someone else. And everybody kind of just accepts it as a right for these portals to exist. But that was just a money grab on the part of associations and MLSs with the syndication fees they generate with these listings going out to these portals. But there's no right to do that. The industry went in that direction for whatever reason. That was around the time I was getting into the industry in the early 2000s. To be honest, Zillow was not even in existence when I started. So a lot has changed over the years, and a lot of change is good, right? Evolution is good. For instance, at one time, you didn't even sell other brokers' listings. So I think we came to see through evolution that cooperation, was good. So, I'm not going to just bash Zillow, but I just thought it was interesting that the Maryland Realtors came out against these touring agreements or said they weren't in compliance with Maryland law. They also noted here, I'm looking at that E&O policies would deny coverage if the agreement did not or the broker did not receive compensation. Of course, these touring agreements stated that there was no compensation for the tour and there was no agency that was created by signing the agreement. But if you go on and you read this blog here that Maryland Realtors put out today, it's kind of interesting because to provide brokerage services, showing a home is providing brokerage services. And if you're showing a home and providing brokerage services, you have to have a buyer brokerage agreement establishing a brokerage relationship. So this touring agreement does not accomplish that. And if you are showing properties, of course, you would be representing the seller. Now, what I think is interesting is that this industry has allowed a lot of agents to get away with, in Maryland and I'm sure elsewhere, showing listings and not identifying to the listing broker that you are actually showing that property as a sub-agent. I just know this. I mean, I know there are certain firms that just run on out or send whatever employee is on call to go out and show a property when a lead comes in on the website. You can't tell me that 100% of the time there's a buyer agency agreement in place. Now, again, I'm not going to be so, righteous that we can't admit to, on the other hand, that plenty of agents have shown without buyer agency agreements to past clients, friends, etc. It's hard to be perfect 100% of the time. So again, I get it. But Maryland Realtors coming out against these touring agreements today. Of course, a lot of the big teams in Maryland, a lot of the big brokerages are dependent really on Zillow continuing to feed their lead pipeline. and Zillow is just one source among others. But Maryland Realtors coming out today saying these touring agreements are not compliant with Maryland law. Yesterday, the Virginia Association of Realtors came out and said as much. So, state associations across the country are coming out against this. And so brokers who were possibly planning to create their own touring agreements and perhaps do those tours for a fee, that seems like that's going to be less possible as well. So everybody's rushing to get out ahead of the NAR changes. And of course, today I have here in front of me the frequently asked questions from Katie Johnson that she put out. She's an attorney pretty high up at NAR. And it looks like August 17th is going to be the mandatory date when these policy changes need to occur with these MLSs. Originally, they were talking about kind of a late July time period. Again, now MLSs will be required to comply by August 17th. So on this topic and on a lot of the posts from the National Association of Realtors, I'm seeing a lot of comments, a lot of conversation among agents about leaving NAR. I do think NAR is expecting to take a hit there. I have not heard of in Maryland, but I'd be curious if you have of any major brokerages who have left NAR. But I know from attending the Maryland Realtors webinar on the NAR settlement a few weeks back, it seemed that even the leadership there expressed a lot of confusion and anger towards NAR. So, will major brokerages leave? Will they create their own forms? To some degree, as a list, if you were a listing firm solely, you could probably get away with having not a lot of forms, right? Because you would just need a listing agreement. By the way, when I started, my company had a listing agreement that was one page. It was on a legal piece of paper. A lot of people may not even know what that is, by the way, but I'm not going to answer that. But it was on a legal form, and it was one page. So if you were listing a property, you needed that, a federal lead paint disclosure, and a Maryland disclaimer statement. So if you were solely or strictly going to handle listings, and you weren't a member of a realtor association, you would probably be good to go with a very small number of forms. And buyers agents, of course, could bring contracts on your properties. And presumably if they're an association member, they have access to plenty of forms to write their contract. And really, alternatively, if you were a firm focusing on buyers, you could create a rather simple contract, a simple buyer agency agreement. The firm that I own, which I've been with for my entire 21-year career, we had a buyer agency form that was produced in-house, or I should say was an in-house form. It was written by our legal counsel and available for our agents, and it was a short buyer agency agreement. And again, it was a half a page. So, you get rid of some of the redundancy, some of the monotony, the legalese, the almost over disclosure that can occur. For instance, the addenda, the attachments, the notices, all the stuff we couldn't fit into the agreement or the contract, all that stuff. When you take that away, that kind of changes the length of the form. So you could go the route as a brokerage team or agent of doing buyer agency and in-house as a non-association member, certainly. Now, I'm just throwing these things out there because these are conversations I've had and things I've read. These are not things that I am personally doing or that I am advocating for or that I plan to do even. They're just, different comment threads I'm reading on Instagram and YouTube about agents saying they plan to leave NAR over their anger regarding the settlement. I personally think it's too soon, too early to evaluate the effect of the settlement. August 17th even is still a number of months away, if I'm not mistaken. That's 3.5 months away. So, why the rush Why be hasty about it when you haven't even seen the changes go into effect? Presumably, turn towards the last topic here, presumably a lot of the communication regarding compensation will be accomplished via forms. I can tell you where it's not going to happen is the MLS, the subsidiaries of the MLS, the aggregated sites that feed off of the MLS, including the broker sites. It's not going to happen in show and time. It's not going to happen in your document section of MLS. It's not going to happen on your broker site, like I just said. Everyone is going to run as far as they can from that. I am assuming that the associations are not going to run from that they're going to create forms that are going to facilitate this communication. I think that agents' biggest fear of having to contact 10 agents 10 listing agents on a Saturday to find out the fee in advance, I think is going to be not only impractical, but I think it's nearly impossible to do. We all know that if you contacted 10 listing agents, even on a Friday, to ask that question, you would not get an answer back from most of them, nor should they have to be available to answer that question at all times. I think that's unreasonable as well. So I do think that what you're going to see is associations lead the way with companion forms for your buyer agency, for your contracts themselves, that are going to largely facilitate that communication of the commission. And I believe that the commission is going to get tagged onto the contract via these forms. And I think you'll see some sort of trend begin to emerge. Certainly, there's the possibility that a buyer's agent contract that has a lower fee attached to it for the buyer's agent will result in a higher net to a seller. So I do think that the plaintiffs in the Burnett case may get their ultimate outcome, which is that competition on buyer agent fees. The industry, of course, has contended that the competition existed, or the right to negotiate was there. And there is truth in both of those statements. There's truth in the fact that there was negotiation, there was competition to get buyer agents, but there was not a lot of negotiation on the back end, or, for instance, when a buyer's agent submitted a lowball offer. I mean, let's be real. How many times did your seller go back and in their counteroffer reduce the commission fee? One would think now that may start to be more common. So I do think that buyer agency is a good thing. That a lot of folks think that this whole lawsuit is like a big step backward for the industry. Those who can change and embrace change can advance and can succeed. And I think those who can avoid the distraction as well will succeed. So a lot of change is happening, and I just wanted to bring this update today. And if you have any questions, I'm happy to talk more about the topic. Thanks.